Hello everyone. Today I'll be talking about the recent verdict, which is a landmark verdict given by the Supreme Court, in which Supreme Court held that the daughter's right to inherit the self-acquired property of a father who has died intestate is recognized. This kind of right has been recognized under the customary Hindu law. So, in this case, the issue was the self-acquired property and the father had died intestate. So, the court held that such kind of property can be inherited by the daughter and daughter has this right. So, in such cases, the property should devolve by inheritance and not by survivorship. Now, why this case is important? Because last year also one case came which talked about the rights of the daughter, that daughters have equal rights in the co-partnership property of the Hindu undivided family. And this case was Vinita Sharma. This case was a landmark judgment which talked about this, which said that once a daughter, always a daughter. It doesn't matter that the issue was before the amendment or after the amendment, because both these cases falls under the Hindu Succession Act. Earlier, under the Hindu Succession Act, there was no concept which talked about the rights of a daughter who should get the equal rights under the co-partnership property. But after the 2005 amendment of the Hindu Succession Act, it clearly laid down that daughters also have right in their co-partnership property, So this case became important, in which they said that it doesn't matter that the issue was before the amendment or after the amendment. Once a daughter, always a daughter, and daughter has the equal right under the co-partnership property. Now, in the current judgment which we are talking about, why this issue came, why this case became a landmark judgment, why it is important? Because in this case, the issue dates back to the year when Hindu Succession Act was not enforced. It was not even present. So now the issue came that whether Hindu Succession Act should be applicable or not, or how it will be applicable, how it should be reviewed. So before starting with the facts of the case, before starting what the court said, what the issues were, we will first understand some concepts about the Hindu Succession Act. So Hindu Succession Act 1956 is an act that relates to the succession and inheritance of the property. This act lays down a comprehensive and uniform system which incorporates both succession and inheritance. And this act also deals with the intestate or unwilled succession. So now I will explain you some concepts of Hindu Succession Act, because when we talk about this act, there are two kinds of property which are dealt. So the first property is the co-partnership property. Co-partnership property is a property which can be said to be an ancestral property, and it needs to be divided equally between all the co-partners. So you can understand it to be an ancestral property that you have got from your ancestor. The other kind of property is the self-acquired property. Self-acquired property is a property which a person has bought himself. It is something which he or she has not derived from his or her ancestors. So it is a property which one has bought for himself, and it has not been derived. It is not a co-partnership property. It is not an ancestral property. Then we will talk about the succession. So there are two kinds of succession. One is testamentary and the other one is intestate. Testamentary succession is a succession when the property is governed, when the succession of the property is governed by a testament or will. which we also known as wasiyat, then it is referred to as a testamentary succession, that already there is a will, already there is some wasiyat, and the whole division of the property is being done in accordance with that particular will. The other kind of succession is the intestate succession. It is a succession in which a person has died and he or she has not written his or her will. There is no testament that is present. So in such cases, the division of property, this distribution is done in accordance with the laws of inheritance, in accordance with the classification of heirs that has been provided to us under the Hindu Succession Act. So according to this act, these heirs has been provided under 4 categories, that is class 1, class 2, class 3 and class 4. And there are a number of people who have been given this, who are there in these categories. Like if we talk about class 1, then under class 1, who are the people who fall under that? They are son, daughter, widow, mother, son of a predeceased son, widows of a predeceased son, etc. So these are the people who comes under class 1 here. Now, second is class 2. If we talk about class 2, then in that comes father, sons, daughters, son, sons, daughters, daughter, brother, sister, daughter, son, son, etc. So these are the people who comes under class 2. Then there are 2 other categories. So if no one is present, first when the distribution starts, the first option is given to the class 1 here. Okay, so who all comes under class 1, the property will be divided amongst them. But supposedly, if there is no one alive in class 1 here, then it will go on to the class 2. And if supposedly there is no one alive in class 2 also, then it will devolve upon class 3. So class 3 years consists of agnates of the deceased. Who are these agnates? An agnate is a person who is related to the intestate only through male relatives. Like for example, A is a person, okay, A is a person who neither has parents nor has any issue. He never got married, so he don't have any spouse, and he don't have any brother or sister. He was a single child. So in such case, the property might devolve to the to his uncle or his aunt who is from the father's side. Okay, so who are related to the male relatives. So these are the people who are called agnates. And agnate can be a male or a female, it doesn't matter, but their lineage should be from the male side. Then if not even class 3 heirs are present, then this property, this distribution will devolve upon class 4 heirs. Class 4 heirs consist of coagnates. So a coagnate is someone who was related to the intestate, to the deceased through mixed relatives. Meaning in this, not only male relatives, not only the male lineage of the relatives, but female lineage of the relatives will also be involved. Like any person who is from his mother's side. Okay, from his mother's side, like Masi, Mama, any kind from the mother's side. So this is class 4 heirs. And if no one is present, no class 1, class 2, class 3 or class 4, then the property will devolve upon the government can take up the property. So this is the succession rule that has been provided under the Hindu Succession Act. And this was all in short that was important to understand this particular case, the present case which we are talking about. So the case is Arunachala Gounder versus Ponnusamy. Now, in this case, the case was decided by the bench of Justices S. Abdul Nazir and Krishna Murari. In this case, a Hindu man named Marappa Gounder had a self-acquired property, and he died leaving behind a daughter, Kupai Amman. So when he died, he didn't make any will. He had no will. He died intestate. And who were the people who were left behind? He had one daughter, Kupai Amal, and he had a younger brother, Ramaswamy Gounder. So this Ramaswamy Gounder had 5 sons. Okay. So the daughter, Kupai Amal, died. And she died issueless. She had no children. And this property was acquired by the 5 sons of his younger brother, Ramaswamy Gounder. And one of his sons filed this petition for the partition of the property. Now, in this case, the issue before the court was, there were 2 issues majorly. First issue was that can daughters inherit the self-acquired property of their father who died intestate or devolves on father's heirs through survivorship. So this was a question that who will get this property? Who will get this self-acquired property of the father who died intestate? Whether it should be given to the father's heirs, whether it should be divided in accordance with the inheritance or survivorship. So in this case, the Supreme Court observed that a daughter is capable of inheriting the self-acquired property or share received in the partition of a co-partnership property of her Hindu father who has died intestate. So it should devolve by inheritance and not by survivorship. It was clear by the Supreme Court. Next issue is that upon whom will the property of the female dying intestate devolve, which is also applicable in this case because the female, the daughter, had no issue, had no children. So in such cases, a female who has died intestate, to whom the property will devolve. So in this case, the court explained this issue with the help of the Hindu Succession Act, the section 15 of the Hindu Succession Act. And it said that if a female has acquired the property from her father or mother and she has no issue, she has never been got married and she dies intestate, in that case, what will happen? That particular property will go back to the heirs of the father or the mother, whoever's property she had acquired. So the property will go back to the heirs of the father, or if she has acquired it from her mother, then it will go back to the heirs of her mother. But in case if she has died intestate and she has a husband or any issue alive, then that property will go to her husband or to her issue. Same is the case if she has acquired any property from her husband or from her father-in-law and she don't have any issue and she dies intestate. In that case, the property will go back to the heirs of the husband or to the heirs of her father-in-law. So this was the explanation that was given by the court. Now, in this case, court not only observed this, but court also referred to the ancient texts like Smritis, commentaries that were given by the renowned learned persons and held that right of a widow or daughter to inherit the self-acquired property or share or any share received in partition of a co-partnership property of the Hindu male who has died intestate is well recognized, not only under the old customary laws, but also by various judicial pronouncements. So it is very clear that daughters have the right, they have equal right to inherit such property, to inherit the self-acquired property. So this was all about this case. I hope this video was helpful to all of you. Please do like, share, and subscribe to my channel. And in case you have any query in regard to legal matters or law exams, you can reach out to me on my email ID and on my Instagram ID. The link for the same is provided in the description below. Thank you very much.